Well, folks, it sounds like this is it. You have done most of your training to become a medical assistant. You are getting ready to graduate, and you're going to sit for that certification exam. Congratulations. So tonight we're going to do a review for the legal and ethical topics that may come up on your certification exam, and I am excited for you. For this review have been taken from previous exams. I looked at the questions and I'm going to give you some basic information just to tuck away in the back of your head with all that other information you've accumulated over the last several years, several months, whatever it's been for you. And we're going to polish things off with some more information. So we're going to talk about contract formation, much more basic than you thought, the fundamentals of agency, the elements of negligence. Remember, I have a tort video, which if you took my class, you've seen it, but it is also available on YouTube. Standards of care, elements of informed consent, and the Good Samaritan statute in Pennsylvania. First topic, contracts. You have had contracts, you formed contracts knowingly or unknowingly throughout your life. When you signed up to come to school, you signed a contract. You signed a contract either with financial aid, or maybe you borrowed money, or maybe you agreed somehow to arrange for payment. And in return for that, the school agreed to provide you with educational benefits. So that is a contract. Also, if you've ever leased an apartment, which we'll talk about as one of our examples soon, that's a contract. Making a purchase with a credit card at a store, you sign that little receipt because you have a contract with the credit card company that you're going to pay them, and every time you make a purchase and you need to sign, you are agreeing to the terms of the contract that you receive the goods from the store, and you're going to agree to pay that store through the credit company. So contracts. So exactly what is a contract? And I'm taking the definition right out of the old exam. It's a nice, neat, very, very clean definition. It's a mutual agreement based on sufficient consideration to do or not to do certain things. I'll repeat that. A mutual agreement based on sufficient consideration to do or not to do certain things. Let's explore. Let's look at the example of renting an apartment. How does that work? First of all, person has something to rent. We'll call that person the landlord. They post an advertisement making an offer to rent. They can put a sign in the window, or they could take out an ad in the newspaper or Craigslist. However they do it, it is an offer for people to come by and offer to see if they are interested in the facilities and the terms of the contract. So we have the prospective tenant enters the ad. Landlord shows the apartment, tells the rental requirements. You have to pay so much a month. You have to shovel your own driveway when it snows. You have to take your own trash out. I will provide utilities, so forth. And those are the terms of the proposed contract. Now, right now we don't have a contract. We have an offer, and we have somebody who showed up to explore the terms of that contract. After some talking, some discussion, some looking around, the tenant and landlord agree. We have agreement between the parties. Agree to the terms of the contract. Now, as far as that consideration between the parties to the contract, let's look at the terms of the agreement. So the landlord will give the tenant the consideration of allowing that person to live in the apartment. That is the consideration. That is what this tenant is bestowing upon, the landlord is bestowing upon the tenant. Okay? So it has to be mutual consideration. So both parties have to be giving something to the other. Remember, our definition is mutual consideration, mutual agreement to consideration. Okay, so the tenant gives the landlord the consideration of payment on a regular basis for the right to live in the apartment. Both parties, landlord and tenant, may verbally agree, yeah, I think you'd be a good tenant. Yeah, I'd really like to rent this place. I think we'd work out great. They can agree on a handshake, or they can be reduced to writing in a document that we call a lease. A lease is a kind of a contract. So the terms have been accepted by both parties. In other words, there is a mutual agreement to do the things listed in the contract. Those are the terms, is the exchange of consideration makes up the terms of the contract. And there's mutual acceptance of that. And that is how a contract is formed. And by the way, in Pennsylvania, the law does honor non-written contracts. In other words, people have come to me when I practiced and they said, oh, you know, my landlord's giving me a really hard time. They want me to move out. Okay, well, what are the terms of your lease? Oh, I don't really have a lease. Okay, so how long have you lived there? For 3 years. Okay, well, the landlord's been letting you live there for 3 years. Yes. Have you been paying rent? Yes, I have been paying rent. Do you pay rent on a regular basis? Yes, I have been. Okay, well then you have a lease. In Pennsylvania, a lease doesn't have to be written down. If the parties have acted in such a manner as though they have a lease, then there is a lease, even though there may not be a written lease. Not all states operate like that, but just as I wanted to mention that because that's a mistake many people make. Here we go again with the elements of the contract, also known as lease, between the landlord and tenant. Landlord and tenant made a mutual agreement. They both agreed based on sufficient consideration. Here we have an exchange of the use of an apartment for money we call rent. They're going to do certain things. Landlord allows tenant to live in the apartment. Tenant pays landlord on a regular basis. Could it be that simple? Yeah, basically it is. Now, complicated things can happen, but I don't think they're going to come up in the context of your certification exam. On contracts, it's an exam on medical assistant matters. Okay, so different kinds of contracts: express contracts and implied contracts. Let's take a look at the landlord-tenant contract. Landlord and tenant express their intent to form the contract when they verbally agreed to the terms, they talked it back and forth, they discussed the terms, and if there is a written lease, the signing of the lease. That is an expression of agreement to the contract. How about well, a good example of an implied contract is your doctor-patient therapeutic relationship. That is usually an implied contract. So, let's put it into context of our contract paradigm here. We have a doctor who makes an offer to treat patients. So, how does he make an offer? He either puts up a sign, joins a big group, and that group puts an ad in the paper. Look, we have a new doctor. Ta-da! Come sign up today and come have our doctor take care of you. And or they do advertising. Just doctor accepting new patients. You've probably seen all of that somewhere, usually in the newspaper. I don't see a lot of doctors advertising on Craigslist, but let me say times are a-changing and nothing's going to surprise me. Okay, so that's considered an offer. Doctor makes him or herself available to patients. Okay, we have a patient who enters the doctor's office, wants to make an appointment, and this is a person responding to the offer. That is not the formation of a contract yet. That is a person responding to the offer. So what happens next? The doctor's receptionist or medical assistant, could be you. You give the patient all those lovely legal documents we've been talking about in class, the notice of privacy practices, the release of information, all those forms, and ask for the patient's information. We'd like to photocopy your insurance card and your driver's license and all those wonderful things that we do up front. So this is what we call exchanging terms. You know, we're clarifying the terms of the contract. Okay, so this is what we do, and this is how we handle your PHI, and this is how we update your EMR and your EHR. This is how it happens. This is how we do business. And the patient says, okay, well, this is how I pay for your business. This is my insurance card, or, you know, sometimes they run a credit check on new patients. Those things happen. So here we are exchanging terms. We still do not have a contract yet. We are merely exchanging terms. So everybody gets their forms to each other. Patient gets the forms filled out, hands them to the receptionist. The receptionist makes an appointment with the doctor. Still no contract yet. We're still exchanging terms. Okay? So appointment time comes. The patient comes into the office at the time scheduled by the receptionist, and the doctor sees the patient and gives the patient the consideration of providing those agreed upon medical services. This is what he advertised, and he gives his product to the patient, the medical services. The patient, in return, gives the doctor the consideration of paying for the services. So, did we actually sign do we have a document here that says contract between doctor and patient? No, we sure don't. But do we have a contract here? Yes, we do, because the parties acted in such a manner as to form. It is implied by the conduct of the parties, and that they did not express the terms on a document or in a conversation. Okay, I'll be your doctor and you be my patient. Okay, you know, we didn't do that, but the implied contract was formed by the actions of the parties. And the terms of the contract were all that paperwork and stuff that they gave back and forth on that very first meeting. So there is your doctor-patient in a nutshell. So when does the implied contract between patient and doctor get formed? It is formed when the parties, patient and doctor, exchange consideration by acting on their agreement. The doctor gives the medical care, the patient provides for the payment. Do I sound like I'm repeating myself? Probably, but bear with me. Okay, so we can all make contracts, but what does it take to make them legally enforceable? I mean, you've heard of people taking a contract out on somebody's life. That's a contract. People are agreeing to exchange consideration to each other for a service to be provided. Okay, well, but is it legally enforceable? No. How often do you see assassins, you know, come to the court and say, hey, she said she'd pay me $25,000 for knocking off, you know, her neighbor, but she didn't pay. You know, it's not legally enforceable. The guy's going to get arrested for for agreeing to commit a crime, for committing a crime. So we don't just want contracts, we want legally enforceable contracts in our world. Okay? So in order to have a legally enforceable contract, both parties must be competent to form a contract. Would you try to make a legally enforceable contract with an 8-year-old? And then, you know, that the 8-year-old must practice piano every day, and if the 8-year-old doesn't, then you're going to sue him in court. It's not going to go very far. It's not legally enforceable because in Pennsylvania, an 8-year-old is not competent because of his or her age to form a contract. Must be 18 or over or emancipated to form a contract. In terms of health care, There are different ages depending on the type of health care being received, right? We know that 14-year-olds can go and get birth control without family consent, without parental consent. So that 14-year-old is legally able to form a contract with the healthcare provider because he or she is of a legal age to get that kind of care without parental consent. So if the person is competent to form the contract, depends exactly on the situation. But if the person is competent to get his or her own health care without other person's consent, then that person is competent to form the contract. Both parties must agree to the terms. Okay, we have the exchange of terms and the discussion and the implicit or explicit agreement to the terms. That has to happen for the contract, for the formation of a legally enforceable contract. You must have that neither party is mistaken as to the terms, or neither party is misleading the other. There must be no fraud. People can fraudulently induce you into a contract by telling you stories and lies, but and maybe you feel like you're bound to a contract, but you're really not if it's not legally enforceable. So it has to be a mutual understanding. You're talking about the same things in terms of the lease. You're talking about the same apartment. Like the landlord's not talking about one apartment and the tenant is not talking about a totally different apartment. You must have an agreement of the terms. There's no mistake as to what the terms are. And finally, each party must offer valid consideration for the consideration of the other party. Let's say Grandpa tries to make a contract with grandson. When I die, you're going to get my Mercedes. Is that a contract? No, it's not. That's a gift. Because grandson isn't doing anything for that Mercedes except maybe saying thank you, but if Grandpa has passed away, what good's that going to do anyway? So there has to be a give and take. Each party must offer valid consideration for the consideration of the other party. Grandson is not offering any consideration to Grandpa for the Mercedes. That's just merely a gift. That is not a contract. Alrighty then, let's talk about terminating the therapeutic relationship. Doctor has a patient. Patient is non-compliant, doesn't take the meds that the doctor prescribes. Or patient has a chronic pain condition and has gone a little overboard with the taking of the narcotics and is constantly seeking the doctor to give more medications, more narcotics, which the doctor does not. The doctor is bound by law as to how much and how often and under what circumstances he or she can prescribe more narcotics, and these aren't those circumstances, so the doctor cannot help the patient anymore, and the patient does not seem to appreciate that and continually bugs doctor for more narcotics. There are many situations in which a physician will need to terminate a therapeutic relationship with a patient. About patient abandonment. This is a situation we're trying to avoid. Patient abandonment refers to the withdrawal from treatment of a patient without giving reasonable notice or providing a competent replacement. In other words, patient has been going to this doctor for years and shows up and doctor says, oh, you know what, I don't see you, you're not my patient anymore. The patient has a real problem. So the doctor has basically abandoned that patient. Patient abandonment is unethical, and it makes the physician vulnerable to a lawsuit for malpractice. This is what we want to avoid. So, how can a physician terminate therapeutic relationship with a patient? Writing a letter to the patient, explaining that the physician can no longer care for that person. You don't have to give reasons. You don't have to list everything, every little issue, what the patient did wrong or so forth. You just explain, I can no longer care for you. And you tell the patient it is in your best interest to find a new doctor as soon as possible. Different states have different requirements, but at least 15 days notice is best. And I mean 15 working days, so you talk about 3 weeks. That's a reasonable time. We want to be reasonable. We want to give reasonable notice to avoid patient abandonment. So in that letter, you inform the patient how to arrange for your records to be forwarded to the new physician. So you can include a consent form, for transfer of the record to the new physician. And finally, you document all of this in the patient's chart, along with a copy of that letter in the patient's chart. You want to retain legal documentation that you're giving that patient a reasonable opportunity to find another doctor, giving them reasonable notice. You send this letter certified mail, return receipt requested, and when that receipt comes back proving that that letter was delivered, you staple that inside the patient's chart or tape it with the letter so that you have complete documentation of how that relationship with the patient was being handled. And that is giving reasonable notice. And you want to avoid those charges of patient abandonment, communicate and document. Let's look at the doctrine of agency. Agency simply means one person acting on behalf of another. It's that simple. Examples of agency in everyday life. An employee is an agent for the employer. When the employee is on duty, he or she is performing a function that employer needs him or her to do. That's the only reason he or she is there for that period of time, acting on the employer's behalf. So an employee is an agent for an employer. Even more familiar, a parent is an agent for a child. Who, signs the child up for school? Who takes the child for immunizations? Who talks to the teacher if the child's having a problem in school? The parent usually does, or somebody acting in loco parentis in place of a parent. The parent is an agent for the child. The child is not able to do these things for him or herself usually, so the parent acts on his or her behalf as an agent. There's the classic real estate agent. That's the person who you tell them what you want, they find you places to look at, and that person negotiates on your behalf with the buyer or seller or whatever the other party's role is. So that's a real estate agent. A lawyer is an agent for a client, represents the person's interests, goes into court and talks as if he or she is the client and makes legal argument on behalf that the client would make if he or she knew how to make them in court. So you're kind of stepping in the shoes of that other person. And agency is all about that. Remember from our Advanced Directives lecture that a medical power of attorney is an agent for the patient. That's the person who consents to certain procedures, to the withdrawal of certain medical services. That's the agent for the patient. Another is a healthcare surrogate, is an agent for the patient as well. So agency is a concept with which you are familiar, but you may not have called it agency. Except now you will, right? Okay, so just to flesh this concept out a little bit, agency is a fiduciary relationship. That's a fancy word. Fiduciary is a person who steps into the shoes of another person and acts on his or her behalf. Or entity. A fiduciary for a corporation represents that corporation in negotiations, in public relations, something like that. So a fiduciary relationship is a legal or ethical relationship between two people, in that one acts to do things on behalf of another. The doer is the trustee. The person doing the representation, acting on behalf of the other, is the trustee, and the person being done for is the beneficiary. And that's easy enough to remember because the trustee has the trust, somebody trusts that trustee, and the beneficiary is getting the benefit. Oh my gosh, can it be that simple? Let's look at another part of agency is agency and liability. Remember that the employee is an agent of the employer. Let's look at a scenario where some liability is incurred by the agent. Employee is on the job, working completely within the scope of practice for his job, acting in accordance to policy, and I have these pretty little signs, pow pow here, but something untoward happens. Something doesn't go right. Remember that the employee is an agent for the employer. Question: who owns the liability for that something that didn't go right? Is it the agent? Is it the employee? Or is it the employer? A general rule, there are always exceptions, but as a general rule, if the employee is on the job, acting within the policy and scope of the employment, then he or she is an agent of the employer, and the employer holds the liability for the untoward event. So, the legal term for this concept is respondeat superior, which is Latin, and it means, literally, let the boss answer for it. So, if you're an employer, you're a boss, and you know that your company could be held liable for some things that your employers do when they're on the job, do you want to hire somebody whose history looks a little sloppy or questionable or seems pretty complacent and not very interested in doing their job well? I don't. When I hire somebody, I want them to be motivated. They don't have to be perfect, but I want them to have sense and be motivated and indicate by their conduct and their appearance and their words that they're going to do their very best as an agent of my organization. So, think about this. How do you want to look to a prospective employer? You want to look competent, energetic, and like you have good integrity. That's what we want. And the employer looks for those things. A little more terminology that I came across, and this is done into more detail in my tort lecture, but res ipsa loquitur, Latin, it means the thing speaks for itself, and this is a theory of negligence. Some cases of medical negligence are easily settled in that it's pretty obvious that somebody made a mistake. The classic example for res ipsa loquitur: the patient has a surgical sponge in his abdomen. We are not born with surgical sponges in our abdomen, are we? No, it looks like somebody made a mistake during their surgical counts during surgery. So the sponge in the abdomen, that pretty much speaks for itself. So yeah, somebody committed negligence during that bowel operation. It can be called medical malpractice. Medical professional liability is the new preferred term, but it all basically means the same thing. If you have a res ipsa case, it is not likely to become a court case since the negligence is pretty obvious. I mean, do we really need to go to court to argue whether it was fully a mistake of the healthcare team? No. We shouldn't have to argue that in court, and who wants to pay all the lawyer and legal fees for that? No. Those cases get settled usually because it is a case of res ipsa loquitur. The thing speaks for itself. basic elements of negligence or medical malpractice, or now called medical professional liability. There are 4, and I pulled this right out of your study guide. Duty, derelict, direct causation, and damages. So basically, the healthcare provider owes a duty to the patient by virtue of agreeing to provide health care. There are certain things that are implied in that. Then next we have some kind of oversight, error, or something goes wrong. There was a derelict in the care provided. Because of the derelict, whatever happens untoward because of the derelict is the damages. But there must be the connection between the derelict directly causing the damages. Okay, doctor leaves a sponge in patient's abdomen. Patient gets a broken ankle 3 months later because he slipped and fell on the ice. Is there direct causation? Did the sponge cause the damages? No. There's enough damage in the fact that the sponge is in the patient. That settles that case, but the sponge in the patient can't be blamed for slipping on the ice and breaking the ankle. Okay? So there has to be causation between the derelict and the damages. And that's where you get most of your lawsuits, based on the, yeah, okay, so there was malpractice, but did it cause, there was a derelict in duty, but did it cause the damages, or were there intervening causes or superseding causes? There's all kinds of, causation itself is a big, big legal issue. I mean, you could study that for a long, long time, but who wants to, right? So, in medical malpractice, there has to be a direct causation between the derelict and the damages to the patient. Patient signs informed consent for cataract removal in the right eye. The surgeon agrees to perform the operation. Because the surgeon agreed to perform the operation and the patient has consented to the operation, there's a duty. Surgeon has a duty to perform the operation to the standard of care, which is present in the community at that time. So there's a duty. Patient is taken in the operating room, is asleep. The nurse preps the left eye instead of the right eye, and the surgeon removes the cataract from the left eye. Here's the derelict. We're going to presume that there was a cataract on the right and left eye, and actually removing a cataract, that shouldn't in itself be so damaging, except that it was beyond the scope of the consent. Patient did not consent to have the cataract removed from the left eye. So the patient did not perform the duty that he or she, the doctor did not perform the duty that he or she agreed to perform for patient, so there's a derelict. Now the operation on the left eye instead of the right eye means that the patient, number one, didn't get the right eye surgery that he or she consented to, and now the patient has left eye surgery that wasn't planned for. So we have causation. Basically goes right back to that derelict, that is operating on the eye which was not consented to. And then the damages are in merely the fact that the patient did the surgery that the patient did not consent to have done. So you have your 4 elements. You have a duty on the behalf of the surgeon, you have a derelict on behalf of the surgeon, you have direct causation because the surgeon's actions caused surgery that was beyond the scope of consent, and then you have damages, unconsented to surgery. So those are your 4 elements. You have to have all 4 of those elements to have a medical negligence case. I go into a little more detail on this and other medical related torts on my other video. Standard of care. Every profession has a standard of care, not just the medical profession. There's just a right way, a general right way to get things done. And anything outside of that standard is not up to the standard of care. So the formal phrase for a standard of care, if somebody is in court for some kind of malpractice in their field, could be a plumber, could be a doctor, could be an airline pilot, pilot. There's a standard of care for each profession. There's just a certain standard that you don't fall below. Okay, the formal phrase in court, this would be asked to the jury. Would a reasonably prudent person, doctor, medical assistant, nurse, airline pilot, and this is an imaginary person that you're comparing the defendant to. So would a reasonably prudent person with similar training, similar experience, in the same geographical location have done the same thing under similar circumstances? That is the question put to the jury after all the testimony and stuff. So what they're asking is, okay, let's create this imaginary person who's just like this defendant on the stand, as close to we can get it. And let's think, would a person with this kind of training, this kind of level of experience in this location, do you think that's a standard? Do you think that's something that person would have done under the same circumstances that the defendant was under? So that's the question, and they decide, if they decide yes, that's something that would have been reasonable to do under the circumstances, then that person has not committed malpractice. But when you think about the standard, would a reasonably prudent person who's similar to this person in the same location under the same circumstances have done this? And your answer is no, they would have done something different. Well, then you would find the person liable for medical malpractice. So that is the standard of care. And you're going to, I looked at your questions, and you need to remember that they compare training, experience, and geographic location and circumstances when they apply the standard of care reasoning. Informed consent. Informed consent is legally prescribed by the patient's Bill of Rights. It is required under both federal and state law. It is an agreement to do something or to allow something to happen only after all the relevant facts are known. In other words, patients have a right to be given enough information to make an intelligent decision as to whether to consent or decline a proposed plan of treatment. Elements of informed consent. These are the things the patient needs to be told before informed consent can be given by the patient. They need to be told the condition they're being treated for, the description of the proposed procedure, who is doing the procedure, risks and possible complications of the procedure, benefits of having the procedure done, alternative procedures, and what is the alternative if no treatment is taken. All of these things must be told to the patient prior to the patient is informed enough to give an informed consent. And the patient needs to really appreciate and understand what is being said to him or her. So who gives the patient informed consent? Who educates them as to all of these issues? Well, let's think about it. Are you and I going to know how to give a patient informed consent about brain surgery? Nope, because we really don't know what all is involved in the procedure, and how can we describe the procedure if we don't know how to do it? And how can we answer questions? And how do we know all the stuff that the patient needs to know, given that we're not brain surgeons? Okay, so no, we're not qualified. Any surgery at all? Nope. I'm not qualified to give informed consent for any surgery at all because I don't know how to do any. Do you? You don't have to answer that. But so the individual who is going to do the procedure, that's the person who knows all the stuff that needs to be known and all the stuff that the patient needs to be apprised of in order to fully explain all the elements of the informed consent. Now you or I, we can witness a signature. We can say, oh yeah, I saw that patient sign that paper. And when they ask us to sign at that witness line, we can legally say, yeah, I witnessed this signature. But I'm not witnessing that the patient had the full informed consent because I really don't have the level of knowledge, training, education, experience to know that. So we can witness a signature, but the person who gives the informed consent is the person who's going to do that procedure. Alrighty, on to the statute of limitations. Statute of limitations is a law that sets a time limit on lawsuits based on an event, which we consider negligence. Okay, I slip and fall on your driveway in 2007. And in 2023, my back starts to hurt. And I want to sue you because I think that happened when I slipped on your driveway back in 2007. Would it be fair for me to be able to go to court and bring a lawsuit against you? Heavens no. There needs to be a limit, okay? And that's exactly the purpose of the statute of limitations. There's a time limit between when something happened and when you can bring a lawsuit on it. The person needs to feel safe at some point that, yeah, okay, at this point, that's so long ago that's not going to come back and haunt me. Okay, so that is why we have a statute of limitations. And I spelled it wrong. I have statute of limitations. So that should be statute, S-T-A-T-U-T-E. Okay, so I apologize for that. I'm going to try to go back and fix that. Anyway, I want you to just be aware that in Pennsylvania, it varies from state to state. The statute of limitations is a matter of state law. So in Pennsylvania, the statute of limitations is 2 years from the time that the malpractice is discovered by the injured party. Okay, so from the time you discover that injury, it has to be 2 years. You have to sue within 2 years of when you discovered the injury. Now, in medical liability for babies, the standard is different. For medical malpractice for babies and children, it is not the same. I don't know exactly what it is. You'd have to look it up. But it used to be they could anytime up to when they're 18 can be a lawsuit, or in some places it's up to age 21. So the statute limitations in terms of minors is much longer than that for an adult. So the standard I'm giving you here is the statute limitations generally for a competent adult. We are not talking about babies. Please feel free to do more research if you need to know more about that. Good Samaritan statute. Now the Good Samaritan statute protects citizens who offer aid to others from later being sued for negligence. You probably heard of people that say, oh, I saw a car accident, but I was afraid to stop because I didn't want to get sued. You know, you hear that happening. So there are 4 things that must be present in order for the Good Samaritan statute to apply. Must be an emergency situation, and the Samaritan is offering emergency first aid or care. Secondly, the emergency must not have been caused by the Samaritan. Third, the care could not have been given in a reckless or grossly careless manner. If you're going to provide care in an emergency situation, make sure you're taking good precautions. Then you should be protected from being sued for something that may not have gone. So in Pennsylvania, we had our Good Samaritan statute enacted in July of this year. And this law protects bystanders who provide emergency care to injured individuals. Emergency care includes first aid, rescue, and moving a person from the scene of an accident to a hospital. Individuals who provide this care are immune from all civil liability unless they intended to harm the injured person or were grossly negligent. To be covered under this law, the bystander must possess current certification in first aid, basic life support, or advanced life saving through the American Red Cross, American Heart Association, or equivalent. And finally, ambulance drivers are not covered by the law and may be sued for damages in court. And this is from the website Law Firm for Life, and I got it off the website and I accessed it on December 8th of 2013. let's look at the Hippocratic Oath. It is an ethical guideline for physicians. It is one of the oldest binding documents in history. It is the oath written by Hippocrates, and it is still to this day held sacred by physicians to treat the ill to the best of one's ability, to preserve a patient's privacy, to teach the secrets of the next generation, and so on. Now this is just the introduction. It is very long, and feel free to look it up. It is kind of interesting, but that's something you'll need to be aware of for your exam. Oh no, it's over already. Don't you hate it when that happens? Well, you've done it. You've completed the review section on law and ethics. Congratulations. Thank you very much for your attention. If you have comments or questions, I will do my very best to get back to you. But first, I would like to thank you and wish you a very good day and a very successful career.